Hi, my name is Greta. I'm the editor-in-chief of Volume 48 of Vermont Law Review. Don't have to do that. On behalf of Vermont Law Review, we just want to say welcome to our 22nd annual symposium titled Black, Brown, and Behind Bars, the Effect of a Colorblind Carceral System. Thank you for coming to this fantastic event. It is a 2-day event, so we hope to see you here tomorrow at 11 as well. Tonight, we are going to kick it off with an opening conversation by 2 VLGS professors, followed by our keynote remarks by Professor Hames-García. And then we have our first panel of the event, Ni Uno Más, Detention Centers or Prisons, which will explore the treatment of people in correctional facilities and immigration detention centers. But before we begin, I just want to give a shout out and recognize the 2 people who have crafted, organized, and put together every detail of this event, Maya Young and Maylee Carvajal. Yes, round of applause. They are responsible for this very informative and important event and the discussions that we're going to have tonight. So definitely thank and congratulate them within these next couple of days. And then once again, thank you for your participation tonight. We're going to kick it off now with our opening conversation by Professor Brown and Professor Clark. Thank you.
So hello, welcome, and I want to say thank you to the Vermont Law Review, to Greta, to Maya, to Maylee. We're really excited to be able to offer some opening remarks. So I am Stephanie Clark and teach torts and civil procedure and things in the restorative justice program, and happy to be here. You want to say hi before we jump in?
Sure. Hi, everyone. Okay, first of all, if you're sitting way back there in the cozy chairs, come on up. We would love to see your faces closer. I'm Jessica Brown. I teach criminal law. I teach constitutional criminal procedure, and I recently, over the summer, became the director of the Center for Justice Reform. And prior to starting to teach here at VLGS, I was a public defender for many, many years. And so we thought that we would sort of lay the foundation for this weekend's symposium by sharing some data with you to sort of illustrate what we're talking about when we're talking about racial disparities in jails and prisons in the US and in Vermont in particular. So I'll turn it back over to Professor Clark to get us started.
Okay, so as Professor Brown said, what we thought we would do is provide a foundation, sort of lay this foundation for the conversations that you'll be having and that we'll be having in the next 2 days. And to do that, so I'm going to lay sort of a bigger picture with our national landscape and share some information and data, and then Professor Brown is going to talk more locally about Vermont. And so the first thing I want to do is just say that when we talk about incarceration, there's different ways that we can measure that. And so I'm going to talk about 2 just briefly. One is this idea about just taking a picture in time, right? So on an average day, you take a picture of the population across all the facilities in the United States. And I had looked up some data, and I had older data, and that had an average daily population of 547,000 in the US. And I thought, well, I want to find the more recent data. And so the data that I found that's now current is 1.9 million people in one snapshot. Now, we're going to see what that looks like in a minute, but there's a different way to also measure incarceration, and that is through something called jail churn. And what that measures is how many people have actually been booked into a facility across the United States over the course of a year. And that number jumps to over 10 million people in the United States that get booked in a facility. Now, some of those people may be there for a few hours, some of them may be there for a few days, but a whole bunch of those people are also there because they also haven't been convicted, but they can't pay bail to get out. So to just give some context to the number of those people and how those numbers get driven up. So let me show you what at least a picture of what the United States looks like with regard to incarceration. And I have a clicker. So that's the United States. And you can see we've got the United Kingdom right underneath it. We've got Portugal, Canada, France, Italy, Belgium, Luxembourg, Denmark, Netherlands, Norway, and Iceland falling down below it. But that is the reality of the state of incarceration in the United States. So I want to break it down a little bit further, though, so let's look at what it is locally. These are just jails. So this isn't prisons. And the little line that you see going up across there, those are the people that are not convicted. So when you think about the growth of our local jails, it's really being driven by a population of people that haven't even been convicted. Many of those people are there for just pretrial detention. Some of them are there because they are serving sentences in the local jails that are less than a year. But that is a startling number of people, again, in local jails. So I want to now also show you what just the churn itself would look like visually. And I can't take credit for any of this. If you want to find a fascinating site with more information than you could possibly imagine about our carceral systems, the Prison Policy Initiative is the place to go. So if we took prison buses and we filled them and we parked them bumper to bumper from San Francisco to New York City, that's what it would look like for the number of people, again, with that jail churn that actually get booked into facilities over the course of the year in the United States. Again, it's over 10 million people. So now let's break it down in terms of racial disparities, because that's really what we're here to talk about in the next couple days. So you can see the rate of incarceration by different ethnicities, but I will say that what this doesn't take into consideration is what the reflection is of the general population, right? So if we talk about the population and the number of people that are Black, for example, in a community, how many of those people are then incarcerated? The numbers reverse themselves. So smaller parts of our population are overrepresented, I mean, by many times, which I'm going to show you in a moment also, in our prisons and jails. And this is what it looks like in the jail systems. So this is this is the rate. So if you look, this is going to be hard to see, but at the very end of those lines, what you're looking at is the rate of incarceration for Black people. It's how many more times are they going to be in a state facility compared to white people. So in New Jersey, it's 11.9 times as many Black people that are incarcerated in their state facilities than Black people. So this just gives you kind of a snapshot, and that holds true for other ethnic groups too. So, you think Hispanic, Latinx, Asian, and there are so many. I could have included charts for every single, we'd be here all night to look at the statistics. It's really stark. But we also want to talk about just Vermont and bring it close to home, and so I'll turn it over to Professor Brown.
So I want to explain first, actually, that Vermont has what is typically called a unified jail system, meaning, by way of comparison, I'll describe New Hampshire first. In New Hampshire, any person who is sentenced to a period of incarceration of more than 1 year serves that sentence in the state prison facility. There's a state prison for men. I think there are actually a couple of locations now, and there's a state prison for women. Any person in New Hampshire who is sentenced to a period of incarceration of a year or less serves that sentence in the county jail. In Vermont, we don't have prisons, basically. We we have a number of jails, and so someone who's serving a 6-month sentence and someone who's serving a 3-year sentence might be in the same facility. That's definitely true for the women. There's really only one facility for women to serve sentences in Vermont. That's in South Burlington. So there could be a woman in there serving a life sentence and a woman in there serving 3 months, right? For men, the other thing that we do in Vermont is for men with who receive particularly long sentences, like years, we ship them to Mississippi, and they serve their sentences in Mississippi. We've been contracting with the Mississippi prison since, I think, 2018. When I just Googled it recently, I learned that our Department of Corrections had just renewed the contract to continue to send Vermonters to Mississippi to serve their sentences. So this is a snapshot of how many Vermont residents are currently incarcerated. This compares state jails and federal inmates. So like Professor Clark, the graphics that look like this are typically from the Prison Policy Initiative website, which has a ton of information. But the other place that you can get very current information about what's going on with the Vermont jail system is from the State of Vermont Department of Corrections webpage. They update their data, depending on the data, they update it sometimes daily or monthly. So as of yesterday, there were 111 women in jail in Vermont, 1,155 men in jail in Vermont, and 126 men in Mississippi. And of those numbers, 12 of the women are in custody for facing federal charges or serving federal sentences. 41 of the women are detainees, meaning, again, like not convicted of anything yet, just pretrial. And there are 64 men who are facing federal charges and 407 men who are facing state charges who are just being detained right now, not convicted of anything. So I'm sure this is really difficult to see from back there. So it's a pie chart that shows that the biggest piece of the pie right there, the blue, is 1,135 white identified people who are currently incarcerated in, or as of September 1st, incarcerated in Vermont. 100, which is, let's see, 151 black people, 51, 12 Native, 7 unknown, 6 multiracial, and 4 Asian/Pacific Islander, and 51 other. So that orange piece of the pie for the 151 black people who are currently incarcerated in Vermont is about 11% of the jail population in Vermont currently. This is the population of different races in Vermont, of our citizenry. So 93%, almost 94% of the population of Vermont is white. 1.5% of the population of Vermont is black. Native, Alaska Native, American Indian, 0.4%. Asian, 2%. Multiracial, 2%. Hispanic, Latinx, a little over 2%. So when we talk about racial disparities, what we're talking about is that in our citizenry of Vermont, black people make up less than 2% of the population. In our jail population, they make up over 10%, okay? And I think we might be back. Oh no, so I also have some slides from the PPI website just illustrating, again, racial disparities. And a great thing about that website is that you can look at national numbers and you can also look at state by state. So if you want to look at data for another state, you can do it on the Prison Policy Initiative website. But so as of 2021, this data is from, this is people incarcerated in the state per 100,000 state residents in each race or ethnicity category. So per 100,000 white citizens in Vermont, 187 are incarcerated. For Black citizens, it's 1,622. For Native American Indian and Alaska Native, it's over 2,000, because again, they only make up 0.4% of the Vermont population. So this is just another graphic kind of illustrating the percentage of the population that a particular race makes up versus the percentage of the jail population that that race makes up. And I don't think we're going to spend a lot of time talking about this, but you know, when we think about our carceral system, it doesn't just mean we're talking about people in jails or prisons. It also means we're talking about people who are on supervision by the Department of Corrections, but in the community, because as Professor Clark pointed out, some of that jail or prison population is going to be people who are sent back to jail or prison because of violations of probation or parole or some other type of community supervision. Okay, now I think we are back. I'm going to hand the clicker back to you so you can finish us off.
So if any of you have been in my class, you know, I mean, we've just laid a foundation, and I would say it's a pretty bleak foundation. And so if you've ever been in my class, you've heard me say that we're always looking for the cracks in the foundation. And I'm a big advocate of trying to find those cracks in the foundation and think about different ways that we can respond to harm and conflict, and that includes incarceration differently. And so we don't want to leave you with just this bleak picture and bleak foundation, but we really want to draw from restorative justice and just share kind of some final thoughts, right? And one is that restorative responses really can disrupt even moments in this carceral system, and they can really bring, you know, transformation not only to social relationships but also to social systems. So even if we're starting small, there's always an opportunity to use a restorative response to bring people together to do something different, and in doing that, really transform that system. And so it's slow, hard work, but it's worthwhile. And what I'd like to do is just end with a quote from Fania Davis from her little book on race and restorative justice. And this is specifically with regard to mass incarceration. And this particular part, she's talking specifically about youth, because of course, youth incarceration is a whole nother conversation. And so she says, while programs seeking to end youth justice incarceration are of inestimable value, true systems change also requires a parallel organizing strategy to institutionalize restorative justice and other non-carceral community-based healing approaches within restorative justice systems. This strategy would both produce relational and systems change, enhancing the anti-racist impacts and transformative power of the work of both restorative justice practitioners and prison activists. With these enhanced efforts, restorative justice practitioners will address symptoms, not causes, and the prison industrial complex will then continue to remain intact unless we start to address those causes. And I would say that the conversations that we're starting here tonight and will be taking place over the course of the next 2 days are really part of how we do this work. So, thank you.
I just want to, so as I was listening to Professor Clark and thinking about the information we've shared so far, and as Professor Clark pointed out, like, yes, these numbers are bleak, I do want to also add that, I hope, you know, we have a little bit of time left, so I hope maybe we can have a little bit of discussion and maybe some questions. But for example, Vermont's overall jail population has decreased in recent years. I do think that the judiciary maybe was forced a little bit to really start thinking about new ways to manage the jail population when the pandemic happened, right? And I think that seeing that you can let people out of jail and our communities can still be safe, and has helped judges and prosecutors start to see that they can continue some of these maybe changed practices, even though we're not in a peak pandemic anymore. And I want you to be thinking about ways, and I think probably you'll hear a little bit about this from the various speakers over the next 2 days, but ways that we can be addressing our prison population overall. And if we're doing that, then we, I think, hopefully, right, are also addressing the racial disparities, are things like eliminating cash bail. So all of those people who are sitting in jail because they can't pay bail are not sitting in jail. Things like traffic stop policies, where essentially, so, I always, one of the things that I tend to bring up in these sorts of conversations is that the way to minimize racial disparities in the criminal legal system is to avoid criminalizing behavior in the first place, right? So like if we can minimize police interactions, then we're gonna minimize people being arrested for conduct, and we're gonna minimize sending people into the criminal legal system. So a traffic policy that says, basically we're not pulling people over for minor traffic infractions, which then often escalate into bigger interactions between police and drivers or passengers in cars that then often lead to more serious criminal charges than the initial traffic violation would have resulted in. If you as a prosecutor have a policy that we're not going to do that, then you're automatically cutting out a bunch of interactions between citizens and law enforcement, and presumably reducing opportunities for people to end up in the criminal legal system in the first place, which is one way to sort of address racial disparities, right? So think about all those things, and there has been progress, there can be a lot more progress, and then the last thing I'll say, and open it up, is that when we do think about incorporating restorative justice approaches into our criminal legal system with the hope of addressing racial disparities, we have to be thoughtful about making sure you're not basically just moving the racial disparities over to the restorative justice. That makes sense, right? I think that there hasn't been a lot, I haven't been able to find a lot of information about, equity in restorative justice, but in researching sort of like treatment courts, like drug courts and mental health courts and other sort of other alternatives to traditional prosecution that have emerged in recent years in our guns, we're seeing the same sort of racial disparities emerge in those types of approaches that we see in the criminal legal system as a whole. So we do think about, and as we talk about using restorative approaches as a way to, intentionally try to reduce racial disparities in the criminal legal system, we need to make sure that we're not just imposing those same racial disparities into these new approaches. So do you have anything else you want to add, or should we see if anyone in the audience would like to add anything to the conversation or ask a question? That would be wonderful.
Invite conversation, yeah.
It's 4:55. We have 5 minutes. Hi, Marriott.
Just says Vermont residents, and does that include people who have been placed in prisons by Customs and Border Patrol?
I think that the Vermont DOC data does not include people who are in immigration detention. What do you think about the national data on the PPI website?
You can find that number on the Prison Policy Initiative, it's ppi.org, and it's on the slides. But they have specifically that information. I know because I looked at it.
I think and I'll qualify to say that the information that I shared today from the Vermont DOC website, I think does not include immigration detainees, but they have a lot. They break their data down a lot of different ways on the state DOC website, so they might have that information on there as well. Is that Tony back there? Yeah. Hi.
What kind of legislation has been introduced that's maybe helping with some of the decline in the incarceral rates, and is it possible to introduce legislation that specifically pinpoint minorities?
So I think so far the approach that I've seen and been aware of has been more on a county-by-county basis, and it's more of a policy approach by specific prosecutors. But then what I've seen is that those, a policy like, let's say, ending cash bail, a policy is adopted in one county, and then there's a movement to try to pass statewide legislation. So I think that there will be efforts in the coming legislative session in Vermont to try to amend the bail statute applicable statewide. Sort of more controversially are efforts to end, Vermont has life without the possibility of parole. So there may be some efforts to try to end life without the possibility of parole sentences, and also efforts to introduce legislation to, not to get too in the weeds, but essentially like there's a very short window after someone's convicted and sentenced to try to get their sentence changed. It's 90 days initially. And so there's efforts to introduce legislation to allow for what's generally referred to as a second look at very lengthy sentences after a certain period of time. And also to, and this is not just Vermont, but lots of states, a lot of justice reform efforts around the country are also including sort of efforts to cap maximum sentences at like 20 years or 25 years and not have life without parole sentences, because it probably won't surprise you to hear that those sorts of really lengthy sentences, including life without the possibility of parole, are disproportionately imposed in cases where the defendants are not white. So, are you aware of any?
I was just going to add on the flip side, when we're talking about collateral consequences of conviction, which have the same racial disparities, right, in terms of those collateral consequences, but those create a real revolving door, into prisons and jails. And I started to go down a rabbit hole with other data, and then decided collateral consequences of conviction is just a whole other big conversation. And there is a lot of effort by states to try and, in different contexts, remove some of those collateral consequences, which will at least help disrupt, I think, some of the things that lead to the revolving door. So part of an example is the clemency work, right? So the expungements and the pardons, which we do, right? And so, but there's other efforts like that. There's other different ways that that's happening in different states. Another great resource is the Collateral Consequences Resource Center, and they do annually a report card of every single state and how their efforts are, including policy efforts, are tracking with improvement in terms of collateral consequences. So great information there too.
All right, we don't want to delay the keynote speaker, so thank you to Maya and Maylee for having us, inviting us, and for all of you for being here and listening.
Thank you.
Carvajal. This is Maya Young. We've been working on the symposium for a while. So glad to have you guys here and fed. So our keynote speaker this year, we are so honored to have Professor Michael Roy Hames-García. Professor Michael Roy Hames-García studies and teaches about inequalities of race, class, gender, sexuality, and disability in the criminal justice system, from policing and criminal courts to incarceration and reentry. He has served on the Civilian Review Board and Police Commission for the city of Eugene, Oregon. He is currently professor of Mexican American and Latina and Latino studies at the University of Texas at Austin, where his current research looks at the community oversight of law enforcement. He is also a policy expert with the Latino Policy and Politics Institute at the University of California, Los Angeles. Please help me welcome our keynote speaker, Professor Michael Roy Hames-García.
Hi there. Can everyone hear me? Okay, great. I'm never quite sure if this is going to work. I'm actually hearing an echo of myself, so I'm going to really quickly change. Nope, I thought I would have an easy way of changing the audio input, but all right. Oh, it's gone. Can you hear me still? Yes, okay, great. All right, so thank you so much to everyone for this invitation, to Maylee and to Brian for advanced communications and helping with logistics. If it's okay, I'll just go ahead and jump into the talk. Actually, I'm going to preface it really quickly. So this is a talk that it's a project that I just started working on, and it's part of the motivation for it has come out of the people are familiar with the Racial Justice Act in California. It's a law that just went into effect this year, and it essentially allows people with criminal convictions who can demonstrate that there was some element of bias or disproportionality involved in their conviction, and it can happen at different decision points: investigating officer, the district attorney, the jury, or the judge. It allows them to have a hearing to possibly get a new trial. And in communicating with some of the public defenders in California, it's become clear that people know very easily how to, well, not very easily, but people are familiar with how to demonstrate bias, racial bias against African Americans in the criminal legal system. And so those cases are proceeding forward, but a lot of defense attorneys are unfamiliar with the history of anti-Latina bias in the criminal legal system. And so there's a dearth of experts and studies to rely on in these cases. And so part of what I've decided to do is to kind of supply some of that. And so that's led me to a bit of an analysis of the entanglement of Latinos in the criminal legal system in the United States. And since it's Hispanic Heritage Month, it seems appropriate to present this to you. So let's see, I share and there we go. Ugh, so sorry. All right, let's try this again. Share. No, it wants me to restart. Oh no, there we go. All right, window, that one. There, all right, I'm assuming that folks can see that. So we're gonna go this way because it's, rather than doing the presentation view, because this seems to work better right now. All right, so the title is How Do You Solve a Problem You Don't Know It Exists? Discriminatory Policing, Racialized Mass Incarceration, and the persistent misrecognition of U.S. Latina entanglement within the criminal legal system. So there we go. 4 quick epigraphs to introduce the problem. This is from 1979. Hispanics are made non-existent within the criminal justice system in many ways. The situation may be less consequential than for Blacks, although for Hispanics, the neglect is more pervasive than for any other sizable minority. Often the failure to even notice Hispanics is not benign neglect at all, but is rather an act of deliberate policy by numerous criminal justice administrators. The oversight pervades the criminal justice research community at so deep a level that it should be viewed as ideological. And some 40 years later, this is in the Washington Post, I believe. As a reporter on the criminal justice beat, I often find myself torn because of the incomplete reporting on Latinos in the system. For one thing, the data available is not detailed enough for any meaningful analysis of how country of origin, citizenship status, and geographic location within the United States affect criminality, sentencing, and recidivism. And experts cite several reasons the Latino community has been left out of the debate about policing reform. The historical legacy of police brutality against Black people is well known and documented, dating back to the slave patrols. Many Americans view immigration as the primary concern of Latinos. The lack of a standardized system for reporting police killings means that Latino victims are often miscategorized as Black or white. In addition, Latinos as a group include a variety of cultures with different lived experiences. And this is the most recent of these from a report this year out of UC Irvine. Measuring the Latino population is complicated, and this difficulty is exacerbated by a lack of data in the criminal justice system. Latinos are not systematically counted across multiple decision points in official data sources, an omission with significant implications. While many studies document racial and ethnic disparities in justice outcomes, we lack the capacity to effectively track such disparities in offending and justice outcomes for Latinos. Further, the absence of Latino measures in justice system data may artificially inflate the number of whites in the justice system and masks actual white-Black disparities. All right, so this is, whenever I talk about incarceration to any audience, I always like to start with by making 3 points. The first is that incarceration in the United States is geographically unique. And what I mean by that is something you're probably all familiar with, that the United States imprisons more people than any other country, and also a larger percentage of its population than any other country. Can form many different versions of this particular chart. This one is comparing the United States to NATO member countries in 2020. And what you can see is that, you know, even if we're tempted to talk about Turkey having a high incarceration rate, the word high doesn't even make sense to describe Turkey's incarceration rate or any of these other nations, because the US is so outstrips any other country in terms of the number of people we incarcerate and the share of our population. So geographically unique. The second is that this state of affairs is historically unprecedented. It's not that the US has always had this high of an incarceration rate. In fact, if we chart out the history of incarceration in the United States, this is 100 years from 1880 to 1980, what we see is, you know, some ups and downs, but criminologists in the 1970s were actually writing articles with titles like the steady rate of incarceration, theorizing that much like an unemployment rate or a prime interest rate, that once a country reaches a certain level of economic development, its incarceration rate is going to stay around a certain level. That turned out not to be true. And what we've seen in the United States since 1980 is an explosion of incarceration in this country, the likes of which we don't have comparators for. So it's not like there have been other democracies or other economically advanced nations that have ever done this in the past. The US is the only one, and has only done it in my lifetime. Maybe not some of yours, but within a relatively recent period of time this has happened. The third thing is that this is not racially neutral. These disparities are disproportionate the incarceration is racially disproportionate. And so again, this is probably familiar to everyone. African Americans have extraordinarily high rates of incarceration in the United States. Native Americans and Latinas follow behind them with some distance behind them whites. And of course, it's a commonplace that Asian Americans have a lower incarceration rate. However, once we delve further into the racial complexity of mass incarceration, what we find is that there are other groups that are often not captured in this large scale data. For example, Pacific Islanders, who have also very high incarceration rates, particularly Native Hawaiians and Samoans. Also, if we break up, so this chart shows two different things. The first is it disaggregates data among Hispanic and Asian American groups. And what we can see immediately is that low aggregate incarceration rate for Asian Americans is a fiction that masks hugely disproportionate rates of incarceration for Southeast Asians, in particular Vietnamese and Laotian and Cambodian people who have higher incarceration rates than Mexican Americans in some cases. The second thing this data this chart shows is the disaggregating between U.S.-born and foreign-born Hispanic and Asian American men between ages of 18 and 39 who've dropped out from high school, right? So people who are at the highest risk for becoming justice system involved. And what we see is that and this comes from the scholars at Irvine who first did this study. We're interested particularly in dispelling this myth of immigrant criminality. Data doesn't always do that, and so people still believe this sense that immigrants are responsible for crime. But what we can see, especially if you look at, I hope you can see the pointer, but especially if we look at the group for Mexicans, is that what's driving Mexican American incarceration is not immigration. It's not immigration violations. It's being driven by U.S.-born Mexican Americans, right? The same is true for Dominicans. The same is true for Vietnamese Americans. All of these groups, even white Americans and Black Americans, right? I'm going to come back to some of this data shortly, but I just wanted to sort of put that out there to give a little bit more of a fine-tuned sense of who's in prison. And obviously, if we parse this out differently around federal versus state, we'd see differences because, of course, immigration violations tend to land people in federal prison rather than state prison. But as we also know, the federal prison system is much, much smaller than state and county prison and jail systems. All right, so in looking at studying mass incarceration and policing, which I've done for 2.5 decades, I think, there are a number of critical frames that emerge, and I'm interested here particularly in progressive or radical frames, abolitionist frames that emerge from scholarship that is most interested in substantial social change and radical social change. So the first of these frames for understanding mass incarceration is what we might call a Marxist critique. And so according to this frame, the primary driver behind incarceration and policing is repression of political opposition and management of reserve labor. Jeffrey Ryman, a political scientist, theorized this in the 1970s as a Pyrrhic defeat. So a Pyrrhic victory, as some of you may know from your classics classes if you took one, is a victory that appears to be where you lose so many of your in this case soldiers that even though you win the war, you've actually lost, right? It's a victory that looks like a defeat. Ryman theorizes that incarceration is in fact a Pyrrhic defeat rather than a Pyrrhic victory. It appears that our criminal legal system and prison system is not succeeding in eliminating crime, for example, or eliminating violence. But that's actually only a defeat if you understand that to be its purpose. And what he says is that's not the purpose. What the purpose is to repress political opposition, manage reserve labor, and to create an identifiable criminal class in order to, right, so you have people who might look identifiable, but also once they become system involved, they become identifiable through criminal records, criminal histories, through restrictions on their civil liberties. And so you have this visible criminal class that is able to draw attention away from other sources of harm in society. So your corporate raiders and your environmental polluters and all the other kinds of places where we might look for harm. A refinement of this thesis we can find in work by Ruth Wilson Gilmore, like Golden Gulag, that incorporates the idea of neoliberalism. So as this carceral state begins to grow, it comes at the expense of a welfare state. And so you have a disinvestment in resources that might, in fact, keep people safe, might in fact meet people's needs, and that money is then turned toward apparatuses of oppression. One of the key aspects of this is that you begin to, rather than see people who need public assistance as legitimately in need, you begin to see them as morally at fault. Once they're morally at fault, they're no longer deserving of welfare, they're deserving of punishment. And so you can see how that works. Second frame is anti-Blackness. And this is most famously put forward by Michelle Alexander in her book, The New Jim Crow. This frame tells a story that begins with slavery and begins to see how, after emancipation, Black labor is in need of discipline by the white elite in the South in particular. That leads to restrictions on their political rights, as well as their social mobility. And a big part of that is the growth of prisons in the South that go almost overnight from 90% white to 96% Black. And you have the birth of things like the chain gang and Jim Crow. Further development of this thesis, we can see in a number of works, Christian Parenti, Naomi Murakawa, who see at this point, at the end of the civil rights movement, the civil rights era, in the 1970s into 1980, right when we see that big uptick in incarceration, they see this as a response to Black emancipation in the civil rights movement. And so there's a repression of Black dissent. There's a war on poverty, a war on crime, a war on drugs, and a war on welfare that in rapid succession, or not so rapid succession if you're living them in real time, curtail the rights and opportunities afforded to African Americans and expand this Southern experiment from Reconstruction of the expansion of Southern prisons, expand that to a national project. And so that's what happens from 1980 on, is you see this massive growth of incarceration in states, even with states with small Black populations. This expansion grows disproportionately at the expense of African Americans. So I'm thinking here about places like Oregon, my home state, or Vermont, where you are. The third frame that's emerged comes about the late 90s and the 2000s. This is Black, Indigenous, and women of color feminisms. And so if you're familiar with the Critical Resistance Insight Statement from 2007, 2008, thereabouts, that's a great statement of this position. Beth Ritchie's book, The Rest of Justice, is also fantastic. Essentially, what this frame does is it takes the previous two frames and it says, these frames are missing part of the picture. They're not attending to gender, they're not attending to sexuality, they're not attending to intersectionality. And so it's a rethinking of the project of prison reform, justice reform, abolition, centering women of color, centering in particular Black women. The final frame I'm going to put out there is Settler Colonialism and Empire. And so this is the most recent of these. It's a great essay if you're looking for reading on this by John Nichols called The Coloniality of, or Colonialism and Incarceration, I think, where he argues against this rhetoric of disproportionality, saying, look, if we're only looking at who's most disproportionately imprisoned, if we're only looking at who's the most imprisoned, we're going to miss in particular the ways that prisons have been a part of the colonial and imperial project and have been used in the project of genocide against Native Americans, and so, or First Nations peoples and Cs in Canada. So it's a rethinking of how we understand incarceration rather than through anti-Blackness or anti-labor. It's saying this is endemic to the project of settler colonialism and has been since the beginning. Kelly Lytle Hernandez, in her recent book, City of Inmates, describes this as an eliminatory option. Right? So the fundamental logic of prisons in her book is to eliminate populations. And she tells a story in the Los Angeles Basin, starting in the late 1770s, about the elimination of Native peoples, then the elimination of white itinerant laborers, Chinese, Mexican immigrants, African Americans. It's a great book, although I'm going to criticize it in just a second. So given these four frames for radical scholarship on incarceration and policing, I want to ask, how do these frames deal with the question of US Latinas? And I'm using the word Latina here. If you're not familiar with various terms, you probably heard of Latinx. Latina is just something that's easier to say than Latinx, but it essentially connotes a similar gender neutral frame. I'm adding US here as a modifier, particularly because I'm interested in capturing the experiences that are not fundamentally shaped by immigration. And there's some reasons for that that will, I hope, become clear. So some limitations of these frames, and I'm drawing here a bit from the work of Lat Crit scholar Stephen Bender. So these frames are limiting. They ignore or mischaracterize policing and incarceration of Latinos in the United States, and they play into detrimental anti-Latina stereotypes, such as the forever foreigner, right? The idea that we are always and only immigrants. So taking those one by one. So the frames erase the specificity of US Latina experience and anti-Latina racism. So Latinas are invisible in a lot of the scholarship. Policing and incarceration of Latinas appear as mere collateral damage of anti-Blackness. So you see this over and over again in otherwise splendid books that I teach regularly and will cite in everything I write for the rest of my life. But what they do is, because the frame is focused on anti-Blackness or on labor, when Latinas are considered, and they often aren't at all, but when they are considered, they're simply seen as, well, there's this massive buildup of incarceration and of policing, and of course there are going to be other people who are caught up in that net as well. And so my concerns here are not directed at any single individual or group, because this persistent misrecognition and mischaracterization and erasure can be found across the best examples of critical scholarship that seeks liberation from racial oppression, gender-based violence, and economic exploitation. But so, for example, in their book, No More Police, A Case for Abolition by Miriam Makaba and Andrea J. Ritchie, you haven't read it, you should buy it and read it. But in this book, the authors, and I'm gonna read a little bit here because I wrote this part out. Activist scholars Miriam Kaba and Andrea J. Ritchie quote Candace Montgomery with the Minneapolis-based Black feminist abolitionist organization, Black Visions, speaking at a rally in the wake of George Floyd's murder, by then Minneapolis police officer Derek Chauvin. Minneapolis, we're here because now is the time to dismantle MPD, the Minneapolis Police Department. Black people and queer people and trans people and indigenous people and disabled people and immigrants and poor people. We have never looked to the police for our safety. We have looked to each other for protection from the police. It shouldn't have taken this much death to get us here. Now, I do not doubt that Montgomery intended no slight toward Latinos and their long history of persecution by police in the United States. I imagine it likely that they believed they had included Latinos by their invocation of immigrants, if not each of the other categories listed. Indeed, some Latinos are immigrants. Some are Black, some are queer or trans, some are indigenous, some are disabled, and many are poor. As a group, however, we are more than these. We are also Latino. We, by and large, share a self-understanding as having something to do with one another across our differences of immigration status, gender, sexuality, disability, or socioeconomic status, across different relationships to indigeneity, and across memberships in racialized categories other than Latino, Asian, Arab, Black, Indian, and white. And so I should clarify here that I'm using Latino, when I use that word, I'm understanding it as a racialized category. And I think that that's, if we look at the history of discrimination against Mexican Americans, Puerto Ricans, it becomes clear that it is a racialized category. Now, we could say it's not a race, but as I hope we all agree, there are no races, right? There are only racialized categories. There are categories that society decides to treat as races, and for the purpose, in almost every case, of disenfranchising and dispossessing the people who are so described. So the legal fiction of Latinos not being a race, being an ethnicity, and of us being, in many cases, considered white, that's a fiction, right? That may look fine, that may hold up when we look at government records, but that's not how people are treated. And so I want to kind of hold on to that as a racial category, not a mutually exclusive racial category, right? Someone can be Arab, Asian, Black, and Latino, but it is still a racialized category. And I take no issue with Black activists, organizers, and scholars centering Black people in their analyses and their movement work. But I find myself troubled by the persistent misrecognition, mischaracterization, and erasure of US Latino colonization, exploitation, oppression, and racialization, especially when these things emerge within radical and progressive scholarship and community organizing. So for example, Montgomery's omission of Latinos in their speech in Minneapolis is echoed over and over again throughout Kava and Ricky's book. And I have some quotes here, right? This carceral approach to addressing society's problems is what claimed George Floyd, Breonna Taylor, and thousands more Black, Indigenous, disabled, and migrant people's lives, and has driven over 2 million people into cages and placed a total of 6 million under control of the criminal punishment system. Criminalization is fueled by the racialized, gendered, ableist, xenophobic, and anti-poor narratives, branding Black, Indigenous, migrant, low-income, disabled, queer, and trans people as inherently dangerous criminal classes. Rates of violence are higher in all categories for Black, Indigenous, disabled, queer, and trans people. And Middle Eastern, Black, and multiracial people, as well as trans, disabled, and low-income people, are most likely to feel uncomfortable seeking assistance from police. Now, this last quote is the most confounding, since the source cited in their book in support of it actually doesn't make this claim. The citation is to a report by the ACLU, the CUNY School of Law, and the University of Miami School of Law. The report does document significant reluctance on the part of survivors of sexual, gender-based, and intimate partner violence to report violence to the police. It also reveals significant patterns of police inaction, hostility, dismissiveness, and bias toward survivors. However, it details, quote, a large number of respondents said the police were biased against women or that their treatment of members of disfavored communities, such as racial minorities, immigrants, Muslims, LGBTQ people, and poor people was a problem, unquote. The subsection of the report titled Racial, Ethnic, Language, and Religious Bias goes on to include quotes from several survey respondents. 5 characterize the experiences of Indigenous and women of color, followed by 3 quotes related to religion and facility with English. Of the first 5 about racial bias, 2 describe bias against Black women, 1 describes bias against Indigenous women, 1 describes bias against Black and Indigenous women, and 1 reads, victims of Hispanic Latino descent are assumed to be lying about the crime to qualify for immigration remedies, even if the victim is actually a US citizen. Now, I've been an admirer of Cava and Ritchie for years, and I do not believe that they would intentionally minimize negative experiences with police on the part of Latina violence survivors. I have to assume then that something implicit and unintentional has caused these radical Black feminist abolitionists to misstate the findings of this ACLU report in such a way as to turn racial minorities in the report into Black and multiracial people in their book, thereby excluding the specific concerns related to Latinas that are addressed in the report. Their failure to recognize Latina oppression, especially US Latina oppression, right? Remember that quote was specifically like highlighting the ways that women who are US citizens are discriminated against as Latinas. But their failure to recognize Latina oppressions, especially US Latina oppression, is particularly conspicuous in this case, but its true significance lies in its repetition over the length of their roughly 300-page book. The results of the ACLU study are again misstated on the following page, where, quote, police bias or discrimination against a particular groups of people in the report is changed to anti-Black attitudes in Cava and Ritchie's text. When this happens again and again, it appears that the authors have learned and are enacting a persistent practice of excising anti-Latina bias from discussions of police violence. What's truly astounding is that neither the authors nor any of their friends, colleagues, or editors or reviewers who read the book prior to print noticed the erasure of Latinas or thought the absence of Latinas in the text worthy of remark. Now, again, if we think back to racial disparities in prison incarceration rates, again, it's not like Latinas are driving mass incarceration, but their incarceration rates are significantly disproportionate, almost on par with those of Native Americans. And so that erasure becomes even more troubling. Another way that these frames work to erase US Latina experience is by casting us as only immigrants, always non-citizens, or primarily defined by the experience of immigration. And there are a bunch of different citations here. I think it's safe to say that most work on Latinas in the criminal legal system is on immigration and understands Latinas as immigrants, either documented or undocumented or both. Kelly Lytle Hernandez's award-winning text, City of Inmates, which I already said I love, is a remarkable history that invites readers to understanding the adaptability of incarceration to target different populations at different times for different reasons. However, Hernandez simultaneously erases Mexican Americans from the history of racialized jailing in Southern California, subsuming Mexican Americans into the category of Mexican migrant. She thereby misrecognizes the oppression and exploitation of Mexican Americans, understanding them as rooted in anti-immigrant sentiment rather than the racism of coloniality. In the process, she provides a compelling study of the uses of incarceration in Los Angeles for controlling and eliminating indigenous peoples, Chinese immigrants, itinerant white men, Mexican exiles, and refugees, and African Americans. Everyone, that is, except Mexican Americans. This is possible in a book about Los Angeles, the second largest Mexican city in the world, and a book by an author surnamed Hernandez is nothing less than astounding. City of Inmates is divided into 6 substantive chapters that trace in chronological order the use of incarceration in the Los Angeles basin to eliminate indigenous people, itinerant white men, Chinese immigrants, Mexican exiles and refugees, and Black people. The 2 of these 6 chapters focus on people of Mexican descent, makes it appear at first glance that this book is largely centered on Mexican American incarceration. However, Hernandez avoids including any sustained consideration of this topic. In fact, she makes an effort on multiple occasions to raise the subject of Mexican American incarceration only in order to dismiss it as insignificant. She thereby minimizes Mexican American oppression while characterizing the role of legal and extralegal violence in mischaracterizing the role of legal and extralegal violence in dispossession and disenfranchisement of Californios, those people of Mexican and Spanish descent who were present in California at the time of US conquest. So she, citing 4 historical studies by Anglo historians, she writes at the end of her first chapter that after US conquest, drought and debt decimated the herds and land holdings of the once wealthy Mexican rancheros across Southern California. I personally happen to be a descendant of those not wealthy and not so wealthy Mexican rancheros across Southern California. My great-great-great-great-grandmother was born in Los Angeles, California in 1800, and her husband was born in 1770 in San Diego, California. And so there were people of Mexican descent present throughout in California and Los Angeles Basin throughout the 19th century. Some of them were wealthy, some of them were not. They did not lose their land holdings primarily through drought and debt, as may come as a surprise. But if anyone has read Monica Martinez's "The Justice Never Leaves You," which is about the dispossession of Mexicans in Texas in the late 19th century, something similar happened in California. There were widespread lynchings, extralegal violence, legal violence, and legal trickery that dispossessed people. That aside, Hernandez moves from this claim immediately into her chapter on how the LA County jail system grew primarily to incarcerate white men. And in order to do this, she first has to dismiss the presence of Mexican Americans as a significant object of concern for incarceration in Southern California. So she does this through some numerical data. When the U.S. Census taker arrived in Los Angeles County Jail in June 1880, he recorded 11 males, 6 European Americans, 4 Mexicans, and 1 Chinese. From a slim majority in June 1880, white males in the city jail rose to 90% of the total number of inmates during the recession of the 1890s. However, if we look at those numbers from the 1890s, Mexicans are not parsed out in those. And so 90% of the total is more or less what Mexicans and European Americans already are in June 1880. And so by comparing apples to oranges, she's able to inflate the number of white men and while disappearing Mexican American incarceration. According to the 1904 Census Survey, immigrants from Mexico comprised only 8% of the white imprisoned immigrants convicted of minor offenses in the Western states. But that's not Los Angeles, that's the Western states. Mexicans did not constitute a majority immigrant group among inmates classified as white by the US Census Bureau in Western states. I'm not sure how that bears on the argument about Los Angeles. While jail registers do suggest that Spanish surnamed persons were incarcerated at roughly twice the rate of the city's Mexicano population, Spanish surnamed persons comprised the minority of individuals booked in Los Angeles County Jail. Law enforcement arrested Anglo-Americans and European immigrant men at a wildly high rate. So I'm not sure what a wildly high rate would be, although it's clear from these numbers that Mexican Americans are incarcerated at twice the rate of their population in Los Angeles at this time. One would assume, therefore, that white men are not incarcerated at twice their rate, and yet somehow this clears the way for the chapter's argument that the incarceration of white men drove the expansion of LA County jail system. So the effects of this, again, are to cast Latina incarceration only as on our radar when it intersects with immigration. But most Latinos are not immigrants. In the case of Puerto Ricans, 98% are US born. In the case of Mexican Americans, it's 72%. And going back to this data, most Latinos in prison are also not immigrants, suggesting immigration is not the primary driver of the US Latino incarceration. Again, here we have Mexicans. I don't have Puerto Ricans on this because they're all 98% US born. But there's another way that these frames work, and that is to cast Latinos as complicit with anti-Blackness, which we absolutely are. Do not take me wrong on this. I was in Los Angeles during the city council for Fracaso last year. Latinos, Mexicans, all of us have been historically complicit with anti-Black and anti-Indigenous racism. But there's an insidious way that this fact ends up implying that gains made by Latinos come at the expense of Black and Indigenous people, and that our setbacks are always compared with those of others and found to be less severe, which they may be, but that's not a reason to ignore them. So I want to kind of wrap up, I think, the formal part of this by thinking about what kinds of alternative frames we can find. And some of these can be found, oh, and this doesn't work unless I actually do it as a slideshow. So let's play concurrent slide, see if that works. Can you still see that? Yes. All right, great. All right, so we've got Latina criminology. And so this is a new field. A lot of these scholars are emerging from traditional criminology departments and finding them in sociology and finding those fields lacking and pushing at the edges of those in order to complicate how we understand Latinos as involved. Some of this work is really good. Some of it is interesting. Often what it is doing, though, is picking up traditional subjects of criminology and simply approaching them with Latinos in view, not necessarily changing the frames. Internal colonialism. So I mentioned Monica Martinez's book, The Injustice Never Leaves You, already. Alfredo Mirande's book is much older and quite frankly dated. But these works understand Latinos in the US, and particularly Chicanos and Puerto Ricans, as the subjects as colonial subjects, as people who have inherited a history of colonial violence, colonial oppression, and along with the racialization that goes along with that. And that racialization is applied unevenly around color and indigeneity and other kinds of factors, but importantly, is not applied to all members of the group. That's part of what makes colonialism work, is that it doesn't matter how high up you are in indigenous social stratum, you're still cast negatively in the light of the colonial power. Anti-Latino racism and resistance is another frame that we see emerging in a lot of work. Juanita Diaz-Coto's work is particularly insightful, I think. This quite simply understands Latinas as a racialized group, a racialized group that has its own history of confronting bias and forming resistance to it. Another framework, and this is the one that I have approached in my own previous work, tries to understand Latinas as struggling against racism and criminalization, but in coalition with African Americans and other groups. I want to highlight here Robert Chase's recent book, We Are Not Slaves. It's an awesome history of the legal writ writer movement in Texas prisons in the 1950s and 60s and 70s. The inmate jailhouse lawyers who basically set the stage for Hernandez v. Ruiz, or I think I'm blanking on the name of that case. The important prisoner rights case from the 1980s. It's a great history. So wrapping up, I just want to say, the existing frames that we have for understanding U.S. Latino entanglement in the criminal legal system are limiting, they're inadequate, and they're obfuscating. Our scholarship and organizing needs to think more expansively than current dominant frames allow. The carceral state is adaptable, and so we have to be as adaptable. If we think about how those four frames that I highlighted, Marxism, anti-Blackness, indigenous and women of color feminism, and so colonialism, right? Each of those built on the back of the previous one, largely through critique of inadequacy. And so I hope that you will receive what I'm doing along a similar vein. I really just want the scholarship to be better, in particular for the kinds of purposes that criminal defense attorneys are needing it to be for challenges under the Racial Justice Act in California. So I'm going to exit out of that, and now I'm on display again, and I guess open up to questions if there are any. I can't hear anyone though.
Hi, thank you. I don't know if you can see all of us, but we're here. Before your talk, Maylee sent us all an article that you wrote maybe 8 years ago about sort of the libertarian and far right case for prison reform and how the progressive case for prison reform and abolition sort of has or has not aligned with that far right libertarian movement. Can you tell us more about just in the past 8 years since you wrote that article, sort of what the update is and how people are thinking about that today?
Oh, yeah. Well, I think that article came out in 2016, and so you know, everything has changed since then, and at the same time, nothing has changed, right? So it really did seem at that time that sort of at the tail end of the Obama administration that there was serious reform was going to happen. And Obama was releasing 1,800 federal inmates at one point, commuted their sentences. I had to pull over and cry on the side of the road when that happened. So it was looking like reform was happening. And what I argued in that piece is that one of the things I argued in that piece is that police organizations saw that the reform was coming, and we're trying to get out ahead of it and say, oh yeah, we can do the reform. We're good. Of course, people continue to be killed by police, and then things came to a head in 2020 with the murder of George Floyd. And what we saw happen was the clamor for reform in policing and criminal justice crescendoed, spilled over into the streets, and the police the cops already had their playbook. I mean, this was the playbook already, and they just accelerated it. So, I watched these committees be set up in city after city after city: Oakland, Eugene, Pittsburgh, Rochester, Nashville. Every city created a ad hoc committee or blue ribbon panel to look into police reform. They all made the same recommendations. There were recommendations flying around from groups like 8 Can't Wait, and over again, I saw police chiefs say, "Oh well, yeah, we're already doing all of that. Yeah, we can do those. We'll do this." And then they did what bureaucrats do. They slow walked reform. They waited out the blue ribbon panels and the ad hoc committees, the special commissions, and what we have seen is not a lot of change. They were already getting out ahead of the spin. So when 2020 happened, they were right there. They lost a lot of PR battles early on because people saw all those awful examples of police violence against protesters. But in the city council chambers and the county commission chambers, they already had the ear of the policymakers. They already had convinced them that they were reformers. And so when push came to shove, not a lot changed. In most places, I don't want to dismiss legitimate victories where they happened, but you've probably seen the articles that there was no large scale defunding. In Austin, there was a vote to defund police, to reduce the police budget a little bit. That ended up not happening. All kinds of things happened in response, so the police budget's now locked in for eternity and can never be reduced because of state law. And but last spring I was sitting down across from an Austin police officer who just shamelessly said, "Oh yeah, well, there's the defunding. You got defunded." And I looked at him and I said, "But my understanding was Austin PD wasn't defunded." And it was kind of like a very brief back and forth. I caught him in a lie, and he backed down. And there had been talk of he and I and this other group of people who were talking of collaborating on a project around code enforcement in dilapidated buildings in East Austin. And he didn't reply to multiple emails after that. So they won't cooperate if you don't buy into their misinformation. I'm sorry, that was a side digression, but all.
Thank you, Professor Hames-García. That is all the time we have before we start our second panel. Our first panel. But we want to thank you once again. Can you everyone please join me in giving him a hand of applause?
Thank you, and I'll just say real quick, if it's a pleasure to be here. If anyone has other questions or wants to be in touch, just send me an email. I'm easy to find on the internet. There's only one of me.
Yeah, I also have the contact, so just let me know.
Great.
But thank you so much again.
Thank you.
Y'all have like 10 minutes.
think we're all set. Okay. Thank you, Jill. Thanks, everyone, for coming back. Again, this is the first day of Vermont Law Review's 22nd Annual Symposium, and we're so excited to have you here. So for this panel, Ni Uno Mas, Detention Centers or Prisons, we have the amazing moderator, Professor Joe Martin-Diaz. Please let's give a round of applause. Joe Martin-Diaz is Assistant Professor and Lead Attorney of Vermont Immigration Assistance, or VIA, at Vermont Law and Graduate School. There, they support student clinicians to advance immigrants' rights through direct legal services, systems advocacy, and community education. Prior to this appointment, Joe was a Vermont Poverty Law Fellow at Vermont Legal Aid and Immigrant Justice Corps Fellow at Sanctuaries for Families, New York. They are licensed to practice law in Vermont and New York. Please, again, can we give a round of applause for our amazing panelists and our moderator, Professor Joe Martin-Diaz.
Thank you, Maya. That's very kind. And hi, everyone. I wish I could be there with you in person, but I am on dog duty. So I'm here in Burlington, coming live. I owe the VLGS website a little bit of an update because this summer I was very privileged to be appointed the associate director of the Center for Justice Reform, where the immigration clinic now lives. So from my new position in the CJR, I manage the criminal immigration clinic program that we host there, newly renamed the Center for Justice Reform Clinic. And I also teach a 3-credit doctrinal immigration law class. I'm excited to be speaking with you all tonight about this panel themed Ni Uno Mas, which is Spanish for not one more. We're going to be talking about all things immigration detention. I'm joined by some excellent panelists, several of whom are alums. So if you'll indulge me, panel, I would love to go one by one and give a very brief introduction about you. And then I would love to kind of let folks introduce themselves and particularly share what called you to immigration legal work and what background you bring to the work, either professional or personal, whatever you feel comfortable sharing with the audience. So beginning first with Aisatu. Aisatu is an immigration attorney in private practice in New York City and Atlanta. She graduated from Vermont Law and Graduate School with a JD MELP in 2018. She's represented detained clients in custody at the Batavia Detention Center in upstate New York, and also clients with ICE detainers in New York DOC and also in New Jersey. Aisatu, I'd love to give you a chance to respond to the question of what brought you to the work and what background do you bring?
Yeah, thank you so much for the introduction. So my parents are actually immigrants. They are from Guinea, West Africa. And so when I was in undergrad, I had volunteered for a refugee center and then just kind of getting the exposure into immigration law, the inequalities, how unfair it is. That's what led me to do the MELP. And then after I did the MELP, I was like, no, I got to continue with the JD. And then just kind of continued looking into like the criminal stuff and then just saw the disparity and the racial inequality there too. So landed here. And I'm so happy to be on this panel.
Thank you. And we're glad that you went for the dual degree and now to have you in practice. This is so exciting. Turning to you, Sue. Sue began her legal career through the Department of Justice Honors Program, which is interviewing several of our 3Ls right now. Very exciting. And also began as an attorney advisor at the Board of Immigration Appeals. She then became an assistant chief counsel and national security attorney for immigration customs enforcement. Then from 2008 to 2010, she served as an immigration judge in Newark, New Jersey, where I have appeared many times. Sue's handled cases on the detained docket in both roles and now also serves as a detained attorney in private practice. Sue, what called you to the work and what professional or personal background do you bring?
Well, for law students, let me tell you, what called me to this work was because as Jill said, I applied through the Attorney General's Honors Program, and the Civil Rights Division had 2 openings, and the Executive Office for Immigration Review had 43. So you're only allowed to pick 2, and I picked those 2. Everybody wants to work for civil rights, of course. So I didn't get the position, but I did get the position at the Board of Immigration Appeals. I was actually editor-in-chief of my journal, not the law review, but the immigration journal at my law school. So that's how I got started. And sometimes it's something as practical as that can lead you all on your illustrious legal career. So don't be afraid to think outside of the box when you're looking for jobs, especially in this job market. And then I went to what was then INS after I left the board, mostly because I wanted to come back to New Jersey, and also when I was working for INS and then DHS, it was a different time. And it was in New Jersey, which is a pretty liberal state to begin with, but our chief counsel said, we're here to do justice. We're not here to detain people. We're not here to deport people who don't deserve to be deported. And I was doing terrorist and persecutor and, sex offender cases. That was my specialty. I was specially trained in that. So, I felt very confident that the people that we were actually trying to prosecute were perhaps people who deserved to be prosecuted, and the people who deserved to stay in this country, worked hard, paid their taxes, had children here, never did anything wrong, were allowed to stay. Of course, that's all changed now, which is why I was not in federal government by the time things have changed, but I would never go back under this, under certainly the last administration, and even this one. There, we'll get into that. There's some issues, so that's why I'm here. And my daughter wants to move to Vermont and go to college in Vermont. So this is very exciting for me. I know.
Well, okay, audience, ask good questions. Be enticing.
Yes, please do.
Thank you, Sue. Thank you, Sue. And Carolina, I understand that, like Sue, you're in private immigration practice, mostly doing immigration work in New Jersey, as well as real estate. I understand that also, like Aisatu, you are a proud swan, having graduated from VLGS in 2005. And like me, you're a proud Cuban. So please tell us a bit more about your professional and personal background and what called you to the work.
So the joke in the family is, growing up, we always talk politics. As Jill mentioned, I'm Cuban American. So we always talked about, what happened with Castro and why my family ended up here. And the joke was, you'll never, maybe Carolina would become a lawyer. And I ended up going to Vermont Law School. And honestly, I had no intentions of becoming an immigration lawyer. I wanted to become an environmental lawyer. I was a very different person back then when I attended Vermont Law School. I was not liberal, as Sue knows me now. Sue knows me personally.
Yes.
I was batting for the other team, I guess. So I literally was pursuing my education at Vermont Law School very differently than most immigration, folks who wanted to go into immigration field. When I got out, I clerked. I had a lot of job opportunities. I didn't do anything immigration related until I got to the Labor Department in New Jersey. And when I was working at the Labor Department, I took on a pro bono immigration case for a young gay man in New Jersey. And it is when I did that pro bono case, I found my passion in life. And since then, I've been representing a lot of unaccompanied minor children, a lot of young men and women in the LGBTQ community, a whole host of families, both in detained and non-detained settings. So pretty much, I would say, I do a lot of family-based immigration removal defense. So that's how I got to immigration. And my parents laugh now because they said, you see, you were always meant to be a lawyer and help the community. So
I love it. So I think I'm hearing that no matter what substantive issues or politics brought you to VLGS, you could do the Center for Justice Reform Clinic, fall in love with your asylum work, and then become immigration lawyers, which is salient because the common application is open right now for spring and summer semesters. So thanks for setting that up for me. I heard in the plenary session, I don't know if you folks had a chance to join, but in the plenary session earlier, my colleagues, Professors Clark and Brown, had the chance to offer up some facts to kind of paint a picture by numbers of what the current status of mass incarceration, particularly mass incarceration of people of color, look like in in the United States at this time. And someone from the audience asked a question whether those numbers include immigration detainees, people who are civilly detained by Immigration Customs Enforcement or Customs and Border Protection. And so what I want to do is quickly offer some of those numbers for the room before we start talking about what the law and policy is that makes this happen. So I am looking at the Transactional Records Access and Clearinghouse, TRAC. Everyone nods because we all know. TRAC is a nonpartisan research organization at Syracuse University, and they crunch numbers on all things immigration court. And what they're reporting, they just issued a new report this week stating that as of this month, ICE had about 35,000 individuals in detention, in civil ICE detention. About 69% of those folks have no criminal records. There are, of the remaining 30%, most have only minor offenses, such as traffic violations. Texas is housing the most ICE detainees. Of the 21,000 people booked in August 2023, of the 29,000 people booked in August 2023, 21,000 were booked by CBP and 7,000 were booked by ICE. ICE alternatives to detention, which are technology-based monitoring programs like ankle bracelet monitoring, or other forms of liberty restriction. They are currently monitoring in that program an additional 200,000 families and individuals as of September 2023. And San Francisco has the most people in alternative to detention program. So I'll stop there. I have other factoids to throw in as the conversation progresses, but I'd love to just hear from you folks about how do we get here? What is civil detention, immigration detention, and how did it come to be? And we can be conversational, and if we get, I can help traffic control if we're all just so excited and talking at once.
I know Sue wants to talk about this. Go ahead.
Well, just briefly, because I'm probably the one who's practiced the longest. I mean, I started at the Board of Immigration Appeals in September of '96, before some of you were maybe even born. I don't know. But why that's so significant is because that's right in between EDPA of April 1996 and IRA of April 1, 1997. And that's where everything changed. And mandatory detention was expanded exponentially, really. And the concept of detaining non-criminal immigrants really expanded. And also, even arriving aliens, that whole concept expanded, which I think we should address a little bit, because that can be very scary, because those can be lawful permanent residents or asylum seekers who are housed in detention centers and are not eligible for bond at all. And that's really scary, because they're not mandatory custody, and yet they can't seek release before an immigration judge. So, but that's when it all started, or expanded.
Yeah, thanks. And I'll just offer for the room that the two statutes that were just referenced, ADEPA and IRA, people refer to them in all different kinds of ways, but for the folks in my immigration law class, those are statutes that materially change the immigration statutes at Title VIII with respect to the kinds of things that will trigger removability and reduce a person's due process rights in the process of removal. So we'll talk a little bit more about that in class. You should take my class. But I'd love to hear a little bit more about what does that, since we have these new laws that have drastically expanded removability and mandatory detention leading to removability, what's the landscape like? What does immigration detention actually look like today? I don't know if Carolina or Isati want to jump in.
Yeah, I can jump in. So I can say that it's when we're looking at like the criminal justice system and talking about the criminal justice system and what it looks like on that, and it's totally different. A lot of the due process rights that someone is afforded in the criminal justice system, I would argue, is not afforded to them in the immigration system. So, you know, having a right to a speedy trial, like I have a case now where someone is in detention and asks for a continuance, and now we have to wait 2 months to go back in front of a judge. And just like Sue mentioned, can't get a bond, so has to sit in detention and just wait for that hearing. So there's also not a right to counsel. You either get your own lawyer or you don't have a lawyer, and you have to give credit to some of the immigration judges who try to explain things, but there's only so much that they can explain. You have a judge explaining things to you really quickly within a matter of 5-10 minutes. And then it's like, what's your decision? Do you want to take an order of removal or do you want to continue? And so that's kind of like the context of what, from my perspective, of what the immigration system is like.
And I think I would add that I would say post-COVID, detention has changed. And also, you know, depending like a state like New Jersey, where we've, you know, basically have kicked out at the county level detention, you know, things have changed for some of our clients that we represent. So now clients have been moved to other states where it's difficult for us as some attorneys to really get access to their clients, for families to really reach out to their loved ones. So there are challenges. I mean, and even during the pandemic that I know my colleagues will comment on, you know, it was very difficult to represent clients because AILA, the American Immigration Lawyers Association, especially the New Jersey chapter, we were suing the government in order to get, you know, WebEx hearings. And, you know, there was a lot of, and we won. And we won. But, you know, there's still these challenges. I mean, I know, and I know Sue and the other panelists can comment on the fact that some of the other challenges will be just even figuring out what court you're in and what jurisdiction applies, because depending on where your client is being detained. So it's not just their rights, it's also just in general, just what law applies and just the logistics.
And just to round out the conversation, when I was an immigration judge back in 2008 to 2010, again, a different time, a very different time, but I did the detained. I did juvenile detention and adult detained cases. And, you know, I was one of those judges who tried to provide explanations to detained individuals. And so did all of my colleagues. For better or worse, a lot of us are gone from the bench now, and the caseload is crushing. It's over 2.6 million cases in immigration court now. That's not an exaggeration. On the other hand, the training that a lot of us got a few years ago is not the training that the judges received maybe in the last 6 years. And they don't, their job is to get the cases done. And so they're not, and their master calendars are huge, and they're not going to spend the time they should be spending on some of these issues, making sure that they protect their rights. And, you know, in New Jersey and New York, we have, you know, our states have given grants to many nonprofit and not-for-profit organizations to help represent especially detained and minor immigrants. But as Carolina mentioned, you know, New Jersey, except for we have one private detention center at the moment that's housing immigrant detainees, although that's going to explode probably by next week because of a lawsuit and all that good stuff. But so all of our detainees have been, and I think most, not all of them, but a lot of them in New York too, have been moved. So we have, you know, most New Jersey detainees now are in either Buffalo, I guess Batavia, Buffalo, Moshannon, which is on the border of Ohio. It's you know, no offense to anyone from Pennsylvania, but if you want to talk about Pennsylvania, that's Moshannon. And or down south, where they don't have access to free and low cost attorneys. It just doesn't exist. And it's a real problem for due process rights for the immigrants.
Yeah, thanks for the overview, folks. I'd love to unpack a few of the concepts that you talked about, just to make sure we're bringing everyone along for the conversation. So first of all, I've heard you say, all of you kind of referred to this in different ways about how folks end up in removal proceedings and then become detained. Like when we say that people are being prosecuted or civilly prosecuted, or the immigration laws are being enforced against them, what does that mean?
Do you want me to jump in first? Since I'm a former prosecutor, I'll jump in first, but I'm not dominating this conversation, ladies.
No.
Okay, so there's a lot of different ways, right? The one that's in the news all the time is, people crossing the border, right? And that begs the whole question, which we can also get into, as to why, just because you're crossing the border, if you're an unaccompanied minor or a mom or a dad, and they run your checks and you don't have any criminal or Interpol hits or anything like that, why you need to be detained at all. But that's a different issue. And so that's one way that you can be apprehended and put into what's called removal proceedings before immigration court. Another way is you apply affirmatively for asylum or adjustment of status or some other relief that you think you're eligible to apply for, and whoever's doing your case decides you're not, and so they send you off to immigration court. Another way is coming through the airport, and for various either you're coming because you're seeking asylum or some other protection, and you may or may not have fraudulent documents because you needed to escape, whatever. Or again, you could be a lawful permanent resident or someone on a business visa who's absolutely 100%, or TPS, temporary protected status, and absolutely be here legally, and yet you've done something that CBP at the airport has determined makes you not admissible to the United States, which is a legal fiction. You actually are in the United States. They let you come in and may or may not detain you, but that doesn't mean that you're actually been admitted. One of those great law school questions. And by the way, if you do decide to do immigration law and you have clients and you do a lot of international cases and you need them to come into an airport where you could actually work with CBP, with reasonable people at CBP, you want them to fly into Newark. People from all over the country tell their clients to fly into Newark because, believe it or not, they're very reasonable, very understanding, not like CBP you read about in the news. So that's my other practical tip.
And I think, Sue, just to chime in, I think another way that people get into proceedings is that, and we experienced this during the prior administration, is, there would be some individuals that would commit crimes. They would be going to state court. And all of a sudden, they maybe have entered a plea deal or they're still working through their process with their criminal defense attorney, and they walk out of the courthouse and they were apprehended by ICE. ICE was checking to see who had court that day, would run a check to see if they were undocumented or not, or if they were, they had a brush with the law and they were picking up people. We also had this in New Jersey where ICE was picking up parents at schools when they were dropping off their children. And I know that there have been instances, we experienced this also, the three of us during the travel ban, where people were being arrested, despite the fact they may have been U.S. citizens, green card holders. So, and even picking up your new dog at the airport, you could be arrested if you don't have the right documents, if CPB's around. So there's many ways that you can be picked up.
Yeah, and then another way, if you have a state criminal conviction that for purposes of immigration triggers immigration consequences, then they can pick you up after you serve your full sentence or when you have your conditional release date. So they will place a detainer on you right when you're about to be released from prison, and then you get transferred into immigration custody.
And one more point about that is where sometimes this is a perfect example of where, the best laid plans, good good ideas can go awry. At least I think this is also true in New York, but certainly in New Jersey, and other, again, liberal states. You know, we have bail reform in New Jersey and New York. So most people in criminal custody, it's assumed you're not going to be housed. You're going to be released from detention unless there's a checklist of 10 variables, unless basically you're very serious criminal, or you have very, very serious charges pending against you, or you're a major flight risk, let's say, you know, a multimillionaire with many passports or something like that. Right. But so what happens is you end up leaving criminal custody when you still have just an arrest. And oftentimes, right, you're arrested for something much more serious than what you're actually going to end up pleading guilty to. That's how our criminal justice system works. Well, because you're released from criminal custody, you roll right into ICE custody without any break, because if there is a break, then you're no longer mandatory custody. And so they have 48 hours to collect you, and they do. And then you can't get bond in immigration. And I'm sure we're going to talk about that too, the difference between immigration bonds and criminal bonds. Because the judge is looking at it, and you've got a charge for, let's say, sexual abuse of a minor under the statute. And then it turns out that, you smacked a child on their behind, which is not, I'm not saying we condone that, but it's certainly not the same thing as, what you first think of when you hear sexual abuse of a minor, right? And so the judge is not going to release you because they think you're a monster. But if you could just get back to your criminal case, right, the charges would be downgraded, dismissed, pled down, whatever, and then you would really be eligible for bond, even in immigration custody. But then there's no agreement between the state, especially if you're housed out of state, with the state and the immigration folks to bring you, to your immigration court hearing, or excuse me, to your criminal court hearing, even if it's by video. Moshannon in Pennsylvania, remember I said Pennsyltucky? You guys remember that, Pennsyltucky? Moshannon, yeah. They wouldn't provide video feeds to criminal court, even if criminal judges were issuing writs. I had a case like that, and the judge had to issue a writ to bring him in person all the way from Moshannon to Philadelphia, and the immigration wouldn't do it. It's a private facility, that's why. And so we had to get the sheriff's office involved, and et cetera, et cetera. It's a real problem. So sometimes what some of us do is we tell our clients to stay in criminal custody longer so that they can get their case downgraded or dismissed before, so that ICE, won't necessarily even ever take them into custody.
Yeah, and I just want to piggyback what Sue was talking about, because in Atlanta, one thing that I've seen, well, Georgia, I should say, is it could be as small as like driving without a license. One thing that happens is you get caught on the road driving without a license. The police don't want to deal with it, so they'll call ICE. ICE will pick you up, and the process will start from there. And in New York, one thing that I've been looking into is hopping the turnstile, right? Just a quick fare evasion that can cause you to be into immigration custody. So it's like, it could be something so minor, or it could be something really, really severe. There's really no in between when it comes to ICE.
Thanks, folks. So what I'm hearing, just to recap, I'm hearing that the immigration laws, based on the way that they were amended in the 90s, they create pretty broad and serious immigration consequences for all different kinds of activity, immigration, criminal, and otherwise. And that a moment when a person comes into contact with government in many different ways, many different forms, is a moment when the federal government might choose to prosecute them for immigration enforcement. And to your point, I saw too, here in the Swanton sector along the northern border, we see the opposite happen, where Customs and Border Protection will encounter someone who is undocumented and maybe arriving and maybe could be put into immigration proceedings, but doesn't want to deal with it. And so instead they call the FBI and have them prosecuted for criminal entry or criminal reentry and taken into federal criminal custody. And so if we're seeing kind of the opposite of these law enforcement agencies kind of passing the charges back and forth. So I want to unpack a little bit when we say housed in an ICE facility or housed by ICE, what are we literally talking about? We've named some famous or infamous detention centers already. And where else? What is it? Where are people actually being held? And when I talk about the criminal legal system, I would say incarceration or prison, right? Cages, like there's a lot of language and concepts that we use to describe what criminal legal incarceration looks like. In immigration, we have a slightly different set of language. What does it look like? What are we actually talking about here? Maybe we'll start with Carolina. Do you want to get going and then we'll pass Aisatu?
Well, I mean, I think it depends. I mean, if you have, and I'll just make it broader, if you have maybe county prisons working with ICE, probably the conditions are much better than the private prisons. I've experienced the private prisons in Georgia, and I was horrified, like literally horrified. Like they probably haven't been updated since the 1950s. And I was driving like a rental pickup truck to go to this ICE detention center. I think it's just even just arriving at these locations, is just it just scares you as an attorney and or maybe the family members, but definitely very different from at the county level in any state.
Yeah, and then you have the federal detention facilities that are controlled by ICE. So these are ICE facilities where it's just people who are for immigration purposes. And then you also have some prisons that contract beds out with and basically pay ICE for those beds, to have those beds. I don't know if there are any others. Those are the three.
Yeah, and that's the model that we have here in Vermont. There are about 60 beds in Vermont corrections that are reserved for federal use generally. And so on any given day, ICE could or CBP could hold folks there, and they do. Sue, did you have anything to add on that perspective?
Oh, the difference between, there is no detention center. There is no jail. That's lovely. Although I have to say, the ones that house juveniles that are run by a state or a government institution are, at least in the Northeast, are pretty okay, actually. Because they're housing juveniles, but all things considered. But the difference between how people are treated, again, more so in the Northeast, but even in the South, at a federal or a state or county facility versus how they're treated at a private detention center is night and day. Again, nothing's beautiful, but I used to go to Essex County Jail, which is literally right up the road from Elizabeth Detention Center. And I never felt, and it has the clanging of the doors and you have maximum security criminal detainees there. I never felt scared. I never felt, I was safe. And you would be walking, and the detainees would be walking right next to you. And there was never any problem. Elizabeth Detention Center, which is in a warehouse, literally a warehouse next to warehouses, is a whole different animal. And I had so many clients before Essex County stopped taking detainees begging me to see if I could get them moved to Essex County because Elizabeth was so bad. It is so bad. And that's the difference.
There were nods of familiarity with those facilities, right? Because if you're practicing in New York or Newark, then folks are, a lot of New Yorkers are being held in beds that ICE is renting from state and county facilities in New Jersey. Interesting anecdote, so we're about to pivot into access to counsel in these facilities. When I was part of the New York bar, I don't want to shame any particular facility. I don't know if it was Bergen or Essex or Elizabeth, but I remember that there was an issue with the detained docket bar, which is predominantly women and people who wear brassieres, were being denied access to their attorney meetings with their clients because the county facilities were, requiring them to remove their underwires because they could be used as weapons. So thinking about the counsel of it all, you've spoken a little bit to what it feels like as an attorney to be rolling up to these facilities to provide legal representation to individuals who are seeking relief from removal. What does access to counsel look like in detention? I don't know, but yeah, go ahead.
Yeah, I could chime in. So usually if the detainee has had their first day in court, they usually, in New York and New Jersey, the judges are pretty good about handing the unrepresented pro se immigrant a packet of nonprofits, which is great. And it's also listed on the Executive Office of Immigration Review. And for those detainees, they'll speak to other detainees because they'll circulate private attorneys or say, work with the American Friends Service Committee or work with this other organization. But it's usually once they, start calling these nonprofits, some of them are overwhelmed. And we're experiencing that all across the country. And so for most of the detainees, unless they have family outside that can help them with private counsel, a lot of these folks have to either wait in line for a nonprofit attorney to help them or a pro bono attorney, or they try to amongst themselves within detention. There's usually like a library, and they all start to help each other out in even filling out a bare bones asylum application. And so they lack access to counsel, I would say, the majority of the folks that are being detained. And the nonprofits are like overwhelmed right now. I'm just focusing on this detained. Non-detained, it's another whole thing. But
actually, so before we leave that point, and then I'd love to talk about bond a little bit, but so why are some folks detained and why are other folks non-detained? Like here at the Center for Justice Reform Clinic, we represent Vermont respondents in removal proceedings who are not detained, who are fighting their removal proceedings in Boston Immigration Court where our cases get venued. So what is the difference typically between folks who are in non-detained proceedings versus detained proceedings?
I can take that. Yeah. So when a person is detained, they're either someone who's subject to mandatory detention. So they're not entitled to a bond. And so they have to wait until their removal proceedings are done. There's also the situation where some people just cannot afford bond. They've had a bond hearing, they've been given a bond, but they just don't have the money. Some judges have very high standards for bond. And then for anyone who's non-detained, it means that they've at one point may have been in detention and were released from detention. So now there are cases out of the docket that the detained judge has. And so they're non-detained, or it could be the situation that Sue had mentioned where you just had an encounter with a CBP officer or someone and they issued you a notice to go in front of an immigration judge.
Awesome. Thanks for clarifying. Oh, go ahead, Sue.
No, just one little statistic I want to throw out there. This is also from TRAC. In August 2023, which was last month, of the people who received a removal order, 16.4% were represented by attorneys. So that means all the rest of them did not have attorneys. And so that just gives you an idea. I don't do math, that's why I became an attorney, right? But that gives you a general idea of how much more likely it is that you will prevail if you have an attorney. And yet there is no right to counsel.
Yeah, it's pretty staggering. And while we're having a numbers break, I'll also offer, apropos of the question during the plenary, so a 2018 report by the American Immigration Council, which is an affiliate of the American Immigration Lawyers Association that Catalina mentioned earlier, they note that as of 2018 in their study, the majority of detainees were men from Mexico or Central America, and many were juveniles. So about 79% of people detained by DHS were men. The population as a whole was relatively young, with the average of around average person being around 28 years old, and over 17% were under the age of 18. Mexican nationals themselves made up about 43% of the detained population, followed by folks from what we call the Northern Triangle region: El Salvador, Guatemala, and Honduras. And the American Immigration Council, in a 2016 report, stated that nationally only about 37% of all immigrant respondents secure legal representation in their removal proceedings. So less than half get access to counsel. So back to we're kind of following the life cycle of a removal case, right, from the moment of from a moment of a person's detention onward. And we've talked a little bit about bond. Oftentimes for a detained person, bond is the very first form of relief under the statute that they're going to be seeking. So can you speak a little bit about what is bond? What do those proceedings look like? What is access to counsel, access to justice look like in bond proceedings?
I'll jump in first, but then I'm going to let my co-panelists talk more about bond. I just want to, not everything is bleak. There's always a silver lining. And one of the, I guess, better things to come out of the whole COVID pandemic, if you could call it that, is more phone and video access to counsel in immigration court proceedings. And now, just like my co-panelists, I can represent a detained individual anywhere in the country and have video or telephone access to them most of the time. So, I mean, in that sense, it is a little better than it was 10 years ago, for sure. So.
Yeah, I appreciate that. And it has transformed the practice of our clinic. We used to drive down to Boston for master calendar hearings and to review case files at the court. And overnights for individuals and clients would have to miss work, and it was horrific. But now we're able to appear by video from Burlington, which is allowing us to represent more folks, and it's allowing our law students, more opportunities to get on the record. So I agree, there's definitely silver linings. And 7 o'clock on a Friday night, and I away from this idea of immigration as part of the mass incarceration phenomenon. So thinking about what is bond, what does it look like to apply for bond? How does that work?
So I guess I'll talk about bond. So usually when I get a call from a panicking family member, my loved one is detained, I want to get them a bond. I usually, it starts off with me really assessing whether that individual being detained is a flight risk, because I have to do an analysis, right? And I need to understand the individual's background, their immigration history, and it's a very short time that I need to not only understand the individual story, but I also have to get documentation, because that's going to be key. And then having that opportunity to speak with the trial attorney about, even if I can get prosecutorial discretion, and sort of get to an agreement for my client. So I think for bond is really assessing that flight risk, looking at why they got picked up. If there's an underlying crime that, they're being charged with or they've been convicted of, I'm going to have to get, proofs of judgment of convictions, dismissals. It's nerve wracking. It's very fast paced. So if you've never done detention work, it's a great way. If you're learning very quickly, you're moving very quickly to defend your client. And, I don't know if my panelists want to get into more of the bond motion aspect, but, really usually the first, you can file for bond at your first hearing. Sometimes some lawyers, basically use that opportunity to explain to the trial attorney, to the judge, look, you may request a continuance because there might be certain circumstances involved, whether it's, the person's a green card holder, or maybe, they have a qualifying relative. Depending on what their defense may be, you might want to ask for a continuance. But sometimes strategically, some attorneys go in and they just immediately file the bond. but they have to be realistic not only with the client, but also with the family members of what their likelihood of success. So it's really, it's a legal strategy. From a strategy standpoint, you have to figure things out.
I also want to say it's almost like a negotiation too, because so I can talk about the bond packet. There are two things that the judge is going to be looking for, and maybe Sue could go into that a little bit more. But is the person a flight risk, and are they a danger to the community, right? And so you want to establish with just like evidence of who the person is going to stay with if they're released, support letters saying, you know, talking about the character of the person to show that they first are not going to flee and do actually want to continue with their full case, and that they're not a danger based off of what their background is. And then you negotiate, kind of, you want to start at a lower point for a bond, right? Like $2,500, but you also need to talk to your client to see what they can afford. But then you just kind of like negotiate there. And at the end, you know, I've had cases where a judge is like, I'm not going to listen to what you say for bond. This is what I'm going to issue, you know, and then you talk to the client to see if they can afford that.
And can I also chime in too, Sue, before you?
Of course, absolutely.
So, and one of the other things is from a strategy standpoint, depending on, you know, the circumstances of the case, what's the form of relief, whether it's cancellation of removal, asylum, you know, maybe you're going to want, you know, that qualifying relative to be there in court to, you know, you might want to call them up as a witness, or maybe, you know, if your client was charged with domestic violence, you know, you may want to have the paramour or the individual that, you know, was involved. So it's really, you know, it's really case sensitive, case fact sensitive. And, you know, you have to move quick. And it is like, you know, she said, in a negotiation, sometimes you can just go straight to the trial attorney.
Yeah, so in immigration court, first of all, bonds are traditionally much higher than what they are in criminal court. I can't remember the time I've ever gotten a $2,500 bond. I was jumping for joy in New Jersey a couple of years back when I got $25,000 bond, because that was the only bond that was issued that day. The judge denied bond to everybody else. Having said that, you know, occasionally a judge will order someone released on their own recognizance, which, you know, is nice. But really, and I actually agree with this. Judges are supposed to look first to see if the person's a danger to the community. And if they decide that they are a danger to the community, they're supposed to stop there. And why I agree with that, before they get to flight risk, is because when you get to flight risk, then all of a sudden, not that anyone's going to really say it, but all of a sudden the person's ethnicity, you know, their economic status, where they're from, their marital status, all of those things that we're not supposed to consider when and it specifically says you're not supposed to consider those things, but they do, because all of that plays into a judge's inherent biases. And I lecture on that often, actually, as to whether or not they're going to release your client on bond. And that's, I think that might be different than criminal court as well. And so I do think if the person's a danger and the judge thinks they're a danger, rightly or wrongly, they're a danger, you just stop there, the attorney takes the appeal. But when you're getting the flight risk, I really think that's where people of color, people of lower economic status, people from the Northern Triangle and Mexico who are considered flight risks, people who don't have strong family ties, that's where they're really going to be harmed in the analysis.
Yeah, I appreciate that perspective. I haven't really thought about the way that the inquiry might stop at the first question. It's interesting just for students who are listening in the room who are thinking about doing this work. Speaking of video access, we've just partnered with the CARE Coalition in the DC, Maryland, Virginia area to start working on appeals of denied bonds, including the opportunity for video appearances when, you know, if the appeal is granted and the case is kicked back to the court level. So that is mitigation work that we're looking at now at the Center for Justice Reform Clinic. I'm curious to kind of pause and zoom out a little bit, because I gotta say, you know, this looks a lot. I mean, we're talking about prisons and we're talking about people who are detained for long periods of time. We're talking about $25,000 bonds or bail, right? $25,000 to be released. And we're talking about no access to counsel. How can this be? How can we detain kiddos and adults for long periods of time and deny them access to counsel and deny them days in court? What's going on here?
I guess I could jump in. I mean, Congress makes the immigration laws. It's federal law. It's not state-based. So this is where we're at. And I think that, if there is going to be change, it has to come at the congressional level. I mean, and also, as we've seen in the prior administration, the executive branch can have an impact. And even with this current administration, can have an impact on how we treat detainees.
And just kind of to follow up on that, I also think that like the difference with this almost being allowed on the immigration side of things is because there's this emphasis that immigration is civil, right? It's not criminal. No one's calling it criminal. So when people are rallying about the criminal justice system and criminal justice reform, it's not being taken into account on what's happening on the immigration side because it's labeled as civil. But I think that there is an argument that someone facing, like a life-altering decision of having to be removed to a country that they don't know is kind of like a criminal punishment. So it kind of should fall, but that's where we need advocacy, we need to get out there and just kind of shed light on the issues that are happening.
And it's politics.
Yeah.
It's politics. The Biden administration, made a proclamation, no more federal detainees in private prisons. Yay. Left out immigration detention, which and why does that matter so much? Because I'm looking for my little cheat sheet here about how much private prisons make. Let me see. Oh yeah, there's two main private prisons: GEO, and CoreCivic. And in 2022, GEO grossed $551 million and $552 million for CoreCivic. That's an insane amount of money that we are all turning over to private for-profit detention centers, right? And there's a big debate as to whether or not any immigrant should ever be detained at all anywhere, and that's a fair debate. But my view is if there are people who should be detained, and I have clients who have committed murder. They're mandatory custody. They were mandatory custody under the original Immigration and Nationality Act until they were granted relief, and my client was granted relief. He was detained. Fair. That's fair, in my opinion. But for example, when Jill was talking about, one of the New Jersey prisons saying that, counsel couldn't go in because they had underwires in their bra. That's a violation of due process, right? That's a county jail. But let me tell you, this is to wake everybody up too and understand what we're talking about here is it was Georgia, in a private for-profit prison 2 years ago, there was a doctor, an OBGYN, who was performing sterilizations on Latina women, primarily from the Northern Triangle, without their permission. He was operating on them, telling them they had cancer or something, and which they didn't have, and performing hysterectomies on a whole host of women detained in a private facility. And think about that. That's horrific. And that kind of thing would not happen in a state or federal run detention center. And if it did, there would be huge outcry. But finally, immigration advocates were able to shut that down and also win reparations for the victims. But think about that for a minute. In the United States, we have people doing forced sterilizations of immigrant women, most of whom were not, I don't think any of them were criminal detainees. I think they were all asylum seekers. Think about that.
So is there a constitutional floor? Are people who are in ICE detention, do they have any constitutional rights?
Yes, yes, they have fundamental due process rights, theoretically. And yeah, and it is not as, and whether, I mean, lawful permanent residents, of course, have more constitutional rights, but even undocumented people who are criminals and entered numerous times, yes, they have fundamental due process rights. And even our Supreme Court says so. I mean, even our, the most conservative Supreme Court we've had in, I don't know, 200 years, 150 years says so, and has ruled that that is the case.
Thanks. I have kind of one last question for the group, and then I'd love to invite audience questions. I'm not quite sure how this works with me being online, but someone is there, Brian or Maylee or Maya, or I mean, someone surely can help. I see Caleb, like someone can ask questions, but I think I want to point to kind of the local context for what's going on here in Vermont. I mentioned earlier that at any given point, the federal government rents about 60 beds from Vermont facilities for general federal use, including for folks in criminal custody or people who are in DHS custody, and that the state is earning over $100 per day per bed to hold those beds. So, if a conservative estimate that at any given time, there's a couple $100s a day that the state of Vermont is making to have ICE beds available for immigration enforcement here in the northern border, which comprises most of the state of Vermont, then it's interesting to juxtapose that with the fact that the state of Vermont does not appropriate a single dollar of state budget for immigration and legal services, not one. Which is why the work that our student clinicians do is so important here in the state, that the clinicians who work with us are really filling a really vital need. What keeps you going? That's something that keeps me going, is this thought that like the student clinicians at VLGS are creating access to counsel in a state that is abdicating responsibility. Right. And in fact, profiting off of the immigration, prison, and industrial complex. So I'm curious to hear, kind of do a go around of what's keeping folks going in this work, and what are your hopes for the future?
I guess I can join in. When in New Jersey, there was this push from immigration advocates and lawyers to get at the county, because we were experiencing the same thing, that the county coffers were being filled with all these contracts that they had with ICE. There were a bunch of us that were advocating to basically stop this. So we would go to those freeholder meetings, the county level meetings, we were doing a lot of protesting. I even went, I protested, and I'll be honest, it's a double-edged sword, because you have to think about, like I said, like even though you don't want the counties, the state to basically have these ICE these contracts with ICE, you also have to think on the flip side, well, if somebody gets picked up, if we end up kicking out ICE out of our state, where are these individuals going? Will they have access to counsel? And I know, I used to argue with immigration advocates in my own state, even though I was working alongside them. As I said, I always reminded them, I'm like, just remember that you have to continue to give them access to counsel. And if this move is to move them to somewhere like across the country, that's not going to help my client. It's not going to help my client's family, keep them going. So, I mean, you have to balance the bad and the good. But at the end of the day, I think, I think Sue and I would agree that, overall, I think we can, as New Jersey, voters, residents, we can sleep at night comfortably, knowing that our dollars are not going to detaining at the county level individuals. But I think it really starts with whether it's representing, going to the Vermont legislature, which I've been to Montpelier when I was a law student, really talking to those representatives and seriously talking like, why aren't we creating a fund? Why aren't we not having this kind of fund? Because in New Jersey, we have that, and I possibly in New York too. I mean, there's funding that's going through Legal Services of New Jersey, and they're splitting that with all the nonprofits and even some of the schools that have all the clinics. So I think it's really important. It's not just fighting in the courts, but also just pure and simple advocacy, which I know Vermonters are really good at. So and Vermont law students.
All right, I'll go next. So what keeps me going? It's hard sometimes. It's actually in some ways harder now than it was 4 years ago, because we were all in the fight together. Almost every reasonable person on the planet, or at least thought that the way that immigration laws and policies were ping-ponging back and forth every single week, where our office and our staff would be here on Friday nights at 2 o'clock in the morning because the law was about to change on Monday morning, and we found out about it on Friday. That's not happening anymore, but we all sort of felt like we were fighting the good fight, and we thought it was going to get easier. It has gotten easier, don't get me wrong, but it's not where we thought it was going to be, and it's hard to stay motivated. So this sounds very like this was a planted question, but it's not. It was true. What keeps me motivated, because I've been doing this now since 1996, and in one guise or another. First of all, I love doing criminal immigration. There's a lot of people, a lot of attorneys who only want to do asylum or family based and all of that because they think, those are the deserving clients, or those are the more interesting cases, et cetera, et cetera. And great, good. I am glad that there's a lot of really good, knowledgeable attorneys helping asylum seekers, helping people who want to bring family members here, et cetera, et cetera. I want to help criminal immigration clients. Not every client I have is a criminal, but a lot of them are, because they need representation. And so what keeps me motivated is sharing my knowledge. And I teach a lot at a lot of law schools, usually not for pay. I am teaching at one law school this fall. I'm teaching at University of District of Columbia, and I am getting paid a tiny little bit. But and I also do a lot of training of other attorneys, because I think it's really important to share my knowledge and see the next generation. My kids are 21 and 22, so they're just a little bit younger than you guys, and they're our hope. And so that's what's keeping me going, using my knowledge to help other people, because we can't all do it alone. There's just too many cases.
Yeah,
Wasn't it a plant? That sounded like a plant, didn't it?
I agree so much with what Sue said. And it's not easy. I've had those moments where I'm just like, is immigration meant for me? Should I be doing this? But I think what keeps me going is, like, I look at it with like small wins. So every time if I'm able to speak with a client and actually give them the information to what their rights are, and they can walk away making a comfortable decision, or if we can fight their case, and if they want to fight their case, just knowing that that client is walking away being fully informed before just taking an order of removal, I'm like, okay, I feel comfortable with myself to keep going on every day. Because the work is rewarding. It's just really tough, but nothing in life is easy. So we just got to keep going.
Thank you for that. Oh, go ahead. Go ahead.
So chime in. Like, what keeps me going is the smiles that I see from the family members, the hugs, the extra little, bonbones or like breads that my clients bring. Not that I need the extra calories, but that's what it is. It's the smiles. It's really rewarding to see, a family stay together, or a couple stay together, or just to see somebody who was painted by DHS, a gang member, and they were not, just because they have a couple of tattoos. I think that's what it is. It's the smiles. It's the satisfaction I get from my clients.
Yeah, that so resonates. I see that we have some audience questions. I'll turn it over to Mystery Voice.
Yeah, that's me.
Oh,
I was just gonna
hello.
say we're gonna start doing some Q&As. So if anyone has any questions in the audience first, we'll take those.
Hello, everybody. Thank you so much for talking with us all. My name is Isaiah Gonzalez. I'm actually Professor Diaz's in immigration class, so shout out to them. I wanted to ask y'all your opinion. I interned for the Executive Office for Immigration Review this past summer, and I had a lot of conversations with immigration judges about how do we fix this idea of getting the immigration courts out of the agency scheme to allow for more constitutional rights to respondents. And so I wanted to talk to y'all how, like, the way you felt about that and address that, because with, as y'all know, with presidential administrations, the way that the law is applied is different. So kind of, like, I just wanted to know your opinion, maybe doing it like a tax court or different things like that, so that way the executive and the agency don't have so much power over people's lives. Thank you.
I'm going to jump in first because as a former immigration judge, I'm a member of the National Association of Immigration Judges, which it was the union. Now it's a collective bargaining organization. And also I'm a member of the Roundtable of Former Immigration Judges, and two organizations that are strongly advocating, as is AILA and many other groups, for Article I courts. And so I strongly believe, especially as a former immigration judge who has watched the due process and fundamental fairness concepts go out the window, depending on who the judge is and where the court is. Yeah, I strongly advocate for it and have written about it extensively. And we lobby at Congress, and we bring it up every single year and all of that. But can I ask you, where did you intern?
El Paso, Texas.
Oh, wow. Good for you. Okay.
Thank you.
So that's my answer.
Do we have any other questions? Because if not, I'll ask mine. So my question is, I guess a little bit more towards like the treatment of non-citizens and how they're housed in these detention centers, and the way that the like lack of reporting of everything that really happens, and it's not until years pass that thereafter news comes out of like the sexual assaults that they've endured, the lost children, the family separations, all these abuses that happen on like it's like daily, it happens every day. Like it's probably happening as we speak right now, and there's this lack of reporting. So where is that discrepancy in the sense of like detention centers and like prisons, where it's like prisons you are able to like somehow, some way, there's some sort of like reporting on them on a yearly basis at least. So where is that same advocacy and knowledge for detention centers?
I guess I can comment about this. I mean, I think that, there is that lack of reporting, but I know that on the ground in different detention centers, because of a lot of certain nonprofits, they're going in, and also there are like, I know in New Jersey, I can speak to there's First Friends. We have some like nonprofit organizations that are not, I would say, a legal nonprofit, but they're just individuals who've come together and they become, friends of the detainees, and they help out, and they start, monitoring, reporting, either going to the local news networks, telling, whether it's the local American Immigration Lawyers chapter. That's how the reporting is actually happening right now, and how we learn about this, or just even just other attorneys speaking about, what they're experiencing with their clients. It's unfortunate that there's not an oversight, but I know that with some personal cases that I've had to like write letters to the county sheriff, get them, other members of county government involved, get congressional representatives involved. So I think it's different for each state.
There is a ombudsman's office now for ICE detainees. run by the Department of Homeland Security. And they don't have a huge amount of teeth, but this is something that was started by the Biden administration, and they are trying. I have had to file several actual formal complaints for clients housed at Moshannon. And scary for anyone who's ever done an immigration case. I have a client who was moved from Moshannon. She is transgender and was horrifically beaten and has suffered permanent physical damage. And they moved her to Chrome, where she feels safe and protected. Chrome is run by ICE, and that's crazy because back in the day, Chrome used to be the worst detention center in the country. That just tells you how things have gotten. But anyway, I filed civil rights complaints, and I always forget the initial CRCS, and formal complaints. And DHS is taking them seriously. That doesn't mean, we'll see what that means at the end of the day. She's still detained because she's mandatory to custody, and I'm working with the ACLU, and they won't release her. But I stopped her deportation. I had a stay filed, motion to reopen, stay filed. St. Patrick's Day, which was also a Friday evening before the Board of Immigration Appeals made the person at the clerk's office at the emergency stay line stay there to make sure that it got filed on time, and she received it, and they granted the stay, and they literally took my client off the plane. So you can see what a geek I am, because look at what I do on Friday night.
Well, Sue, you're in good company because Maylee, who just spoke, is also working on a stay this semester. So she's a geek too.
Fantastic.
And you know, it's funny now that you say that. A law partner of ours who is local counsel is serving as pro hoc for a federal tort claims act case that was filed today in the District of Vermont.
Really?
So there's there's litigation that happens, but of course, like, litigation is about remedying a past harm. So that's a little too late, I think. But it is a tool.
Are there more questions?
So I think that's it, and I think this is also going to be when we're going to give our panelists and our amazing moderator a round of applause.
Can we ask the audience a question? Can I ask the audience a question? How many of you are going to be immigration lawyers? Or maybe going to be immigration lawyers? Okay, good.
We have, oh, Dahlia's here. We have 1, 2, and then me, 3. So we have 3. But I appreciate all of y'all joining. Thank you, Jill. Thank you, all of our amazing panelists. Yeah, and thank you to all the audience members again for coming, and we hope to see you here again tomorrow at 11. But thank you so much.
Thank you all, and
Thank
thanks,
you so
Maylee.
much.
Thank you. Bye.
Take care.
You too. Bye.